you might also have seen the communication sent by our president that CMS had to decide to kind of separate from our Russia office, since on the one side it has become dangerous for them in Russia to be part of a so then you're kind of considered a foreign spy in Russia, and it's on the other hand, of course, also for in today's world, it's kind of not good for your reputation if you have an office in Russia. And so it's not because we have a problem with our colleagues in Moscow, but it's unfortunately today's time which requires such decisions. And so now after having
the name of the office in Moscow.
Excuse me?
What would be the name of the law firm in Moscow? Still CMS, or?
Now it's CMS, still CMS, but the idea is that the local partners there will take over it. And I don't know what the future name will be, but it will no longer then be CMS. But this is, of course, cannot happen within one day.
I see. Thank you.
But sorry, now I took already 5 minutes and I swiftly hand over to Ryan, but we're all happy to see much more people than 2 months ago.
Yeah, so Hannah, are we ready to get started?
Yep, go ahead.
All right, so good morning, good evening, everyone. This is Ryan Kurtz with Miller & Martin in Atlanta. We're happy for everyone that's been able to join us on behalf of Philip Dickenman and Wendy Lynn, the other co-chairs of the Dispute Resolution Practice Group. We're pleased to present to you part 4 of this ongoing series regarding the enforcement of court decisions and arbitral awards abroad, practical insights from our experts on a country-by-country basis. Thus far in our series, we've done, I believe, Singapore, Canada, Spain, and the United States. And today, we're fortunate enough to have Brazil that's going to be presented by Carolina Dotto with the Tozzini Freire firm in Sao Paulo. Following Carolina's presentation, we're going to hear from Peter Bert with Taylor Wessing in Germany. Peter's going to talk to us a bit about taking evidence under the Hague Convention by video conference, which I think will be quite interesting given what's happened in the last couple of years with COVID and the let's say the newfound use of video technology. And then time permitting, we may hear from Yoko Maeda at City-Yuwa Partners, who is going to, Yoko has unfortunately a last minute conflict with a court hearing, but if she can make it, she's going to present briefly the dispute resolution team at City-Yuwa Partners. And if we have time, we'll do some speed networking at the end. So again, we're very happy that you all could join us. And with that, I will turn this over to Carolina, who's going to talk to us about enforcement proceedings in Brazil.
Thank you very much, Ryan. Thank you, Philip. Okay, I will share my screen. Please let me just know if you can hear me well. Yes, okay. So just a second so I can share the screen. Okay. Can you see it already?
We can, but it's not in presentation mode. We can see all of your slides on this side.
Okay, just a second. Okay, maybe now.
Nope. So if you click that third icon in, right next to Do Slide Actual, and next the one in between that and Configure Art, that should give you presentation mode if you click on that button.
I'm sorry, Hannah, which button? I couldn't understand it.
So it's the icon between, and I do not speak your language, so so excuse me for doing this, but it's the icon between Configure Art and Do Slide Actual.
Okay, I will try again. Just a second.
If you click that icon, it should put you into presentation mode.
Yeah, I have put it on presentation mode. It's not working yet.
No.
We can see very large the icons where you kind of decide what to do. Like it's very large. It says do como seu. I don't speak Spanish or Portuguese, and then it's do slide actual, and so we see those, and your slide is very small.
Okay.
Can you see, Carolina, down at the bottom, do you see where it says 10%?
10%.
Way down at the bottom, below the, it's at the bottom of your
below the
PowerPoint
presentation.
Yeah. Do you see that?
The 10%, no. Just a second.
Why don't you drop it into the, or send me an email with it, and I can try to pull it up on mine.
Sure. Okay, sorry about that. I'll send you now, Hannah. Okay, I have sent it to you. Please let me know if you have received it.
Did you send it in email, Carolina?
Yes, I did.
Sorry about those people. Taking just a minute to come through. It is not in my inbox yet.
It is on my sent items, so it should be there soon. I have sent to administrator the Word Law group.
Oh, sorry. It needs to come to my email. I don't monitor that one.
Okay,
so you should have been on the email string with the latest
Hannah.
one with Philip
Okay.
that you sent to me.
Hannah. Okay, now again. Okay, now I sent it to Hannah Shia. Yeah.
Takes a minute for things to get across the world, Carolina.
It should be there soon because it's on my sent items already. It has left my mailbox.
Here we go.
Yeah, okay, good.
Alrighty. Working on it. It's taken a minute to pull it up from my downloads. Okay.
Hannah, does it make sense? We could have Peter.
Yeah, why don't we have Peter? It's taking a long time to open this file for some reason. So we could skip to Peter.
Okay.
Or I can do it without the presentation mode, as you prefer. Or we can go with Peter first.
Yeah. Why don't we go with Peter if that's okay, and then we'll come back
Sure.
to you, Carolina.
Sure.
Well, let's see how that works. This is the screen I want to share. All right. And does it work? Do you see it?
We do, but as with Carolina, we do not see it in presentation mode. We see the one slide and then the rest on the left.
Wir sehen links auch die einzelnen Slides, aber es ist relativ groß, also ich würde starten, sonst
it's very strange because I have presentation mode all over my screen.
Yeah, it was the same with me, Peter. I had the same.
But Peter, start like that because now it's large. When Carolina tried more, it became only worse. We can see properly. Please start.
You'll just have to click on each of the slides or the down arrow
sure.
so that you can go to the next slide when you present, but that's fine.
Actually, the idea was to present very briefly and not in any great detail two very recent developments in Germany, one which is actually working already and the other one which is in the making, which might have practical implications. On the one hand, we now have decisions by German authorities under the Hague Evidence Convention to allow for the taking of evidence by video link, and Germany's position on the taking of on pretrial discovery of documents may soften. Well, first on the direct taking of evidence through a video link, I remember that about a year and a half ago, I was negotiating with authorities in order to allow them to do a video link taking of evidence in Germany in support of US proceedings. And back then, they were very hesitant and they told me things like, well, we've never done that and how should that work? And of course, at the time, there were travel restrictions and witnesses couldn't simply fly to the States. But I was denied these applications back then. And then last summer, in two federal states, the central authorities, being a federal state, we do not have one central authority, we have one central authority in each of our federal states, came around and did grant such an application. And now this combines basically two things. First, there's the commissioner route under the Hague Convention, and that means that the requesting court does appoint a commissioner, and it's not a judge or a court officer in the requested state that performs the taking of evidence. And secondly, is then the technology aspect, the video link. So on the one hand, we have Article 17, which allows, with the consent of the requested state, the person appointed by the requesting state to perform these functions in the requested state. And the second thing is the video technology. The Hague Convention, just when COVID started to become a thing, published a very detailed and very good guide to best practice on how to use the video link. And basically the Hague Convention's standpoint is it's a technology neutral convention, and video links can be used under it. Of course, they started working on this guide about 2 or 3 years prior to COVID, but the publication was very timely. So what happened in this case is that the US court issued a letter of request to the German authorities. And in this letter of request, they said, well, we have appointed Mrs. X as our commissioner, and we ask for permission that she hears these witnesses in Germany, and that the witness testimony is first recorded, and secondly, that there's a video link to the US so that US party representatives, US counsel can listen to the taking of evidence. And with some modifications, this request was granted. And a similar request was filed in a second state. And if you look at these two decisions in conjunction, basically you can say, if the US court appoints a non-party representative, an independent commissioner, then such a commissioner will be appointed. It's fine to do it by video link. It's fine to have a court reporter and to have a verbatim protocol, but no taping of the evidence. So it's a live video link and then a written transcript, but no video of the hearing. And secondly, a German judge must always be present. And that means unless this judge is comfortable doing it in English, you will always have to go through an interpreter. And the idea is that the German judge is present to monitor that procedural rights are not violated. And there are two points that were especially highlighted in these decisions. There should not be a cross-examination of the witnesses because the authorities deem that to be contrary to German public policy. I have my doubt about this because in criminal procedure, we do have cross-examination. And if that really were true, wouldn't we have a risk of arbitral awards being set aside if the witness was crossed? And the second thing is, well, it should not be used as a fishing expedition. So only specific questions would be permitted, and there would be a right to deny the answer to questions that are too wide. So I think whilst this is not perfect, I think it's a very good step into the right direction. If you have cases where you need to take evidence in this country, in Germany, have that in the back of your mind. Even if travel restrictions are lifted, it may be much cheaper actually to do it this way. You wouldn't have to fly in court reporters and counsel and whatnot. By the way, the background to this one case was a patent dispute in the US, and the independent commissioner they appointed was a judge at the Munich Patent Court, one of the internationally renowned German patent courts. And she acted there outside her judicial capacity, in her private capacity. So you could appoint a suitable German judge or indeed a lawyer in a law firm as long as they're not affiliated to one of the parties. And you could get to that taking of evidence almost as if it were direct, rather cost efficiently and speedily. So that was the first development. And so no change of the law, no change of the Hague Convention, just a change in the practice and in the application by the German authorities. And the German authorities in questions were the president of the Düsseldorf Court of Appeals, and the Minister of Justice for Rheinland-Pfalz. They appear to have spoken to each other because the two decisions are like 95% identical, which is also a very good thing. From past experience, I can tell you it doesn't always happen, and you can have identical applications because your witnesses are in different parts of the country. Application A gets denied with respect to witness A in Bavaria, and it gets granted with respect to witness B in Hamburg. So at least on a practical level, they appear to have tackled that issue. And the second point is perhaps even more sensational, but not yet the law. Like many civil law jurisdictions, Germany has made the reservation under Article 23 of the Hague Convention, and we will not execute letters of request for the pre-trial discovery of documents. Now, this is a topic that's been criticized every now and then, and every now and then there have been ideas how to modify that approach. There's always even been one piece of legislation recently that was not being dealt with prior to Parliament coming to an end. As you know, we had elections last year. We have a new Parliament, we have a new government, we have a new Minister of Justice, and now we have a new draft legislation. It would, if implemented, allow executing letters of request for the discovery of documents if certain requirements are met. Documents must be very precisely specified. The parties requesting them must be able to show that they are relevant to the proceedings until the outcome. They must be in the possession of a party, so no third party discovery here. And then there's, of course, the general caveat that the request must not be against public policy. In a sense, that's perhaps something that you might recognize, trying to build a compromise between a pure common law and a pure civil law approach, pretty much like the IBA rules on the taking of evidence in international arbitration. And given that the new minister has now apparently put his weight behind this proposal, I think for the first time since I practice law, I think we stand a chance of changing the law on that and at least get some level of document discovery under the Hague Convention. Of course, the new government has come up with a lengthy list of things they want to achieve, and this is not very high up on their list of priorities. On the other hand, it's a rather technical thing that will not get anyone excited about in the parliament, or very few people will get excited about this at all in the legal community. So on balance, I think we'll see that proposal being implemented within the next year or so. If it gets implemented, I'll let you know. If not, then it's by my count the third or fourth failed attempt to do something. That's been a very quick update on these two issues, and happy to take questions if you have some and if we have time. Thank you.
Yeah. Peter, thank you very much. That was really fascinating. I have a couple of questions. As a common law practitioner, this is really interesting. So with the video taking of evidence, or taking of evidence by video, do I understand that the commissioner is the one that actually asks the questions of the witness?
Yeah.
And so do the lawyers for the parties sort of submit suggested questions to the commissioner, and the commissioner can either ask those questions or some modified version of those if he or she chooses?
Yeah, to that extent, it's pretty much like under the letter of request, where a judge in the requested country would do that. They get the letter of request, they get the questions, and then they just work through that list. I think the big benefit is if you have a state judge doing that, he might be totally unfamiliar, say, with patent disputes. He doesn't have any background. He will not do any background reading. And basically this will make his day miserable. I did assist in such an exercise where the witness was located in a tiny village south of Freiburg, and we ended up having to take evidence for a multi-million patent suit in the US in what is the smallest local court in Germany. And this judge, when I told him, by the way, it's going to be hundreds of questions, you better set aside a day, he fainted. If, on the other hand, you appoint a lady like that very experienced international patent judge in Munich, you get her to read, I don't know, 45, 50 pages, agreed between counsel on the background of the case, and she knows what she's doing. She knows why these questions are asked. She knows where to sort of perhaps follow up, and she is in a position to say, well, this is relevant, this is not relevant. Whereas my poor judge there south of Freiburg, he had no idea what he was doing. Literally, he had no idea what he was doing. And in that sense, the video link increases the quality tremendously if you use the right commissioner. And of course, US counsel can attend, and they can ask follow-up questions, supplementary questions. They can do what at least on German TV, US lawyers do all the time. You can jump up and shout, objection, Your Honor.
Interesting. So, you know, in the US, as many of you know, I mean, we would typically take this kind of evidence and through what we call a deposition, which is essentially a private proceeding in which you sit down in a conference room with the witness, and you have basically 7 hours to question the witness. So doing this in a more formal court proceeding through a German commissioner is quite different and interesting to us. So anyway,
it's maybe also to briefly share, because unfortunately I settled just before I was supposed to act as a commissioner. At least in Switzerland, you would be able as a commissioner to act more like a referee, so that the lawyers would be able to ask the questions directly, but you would have to stop them if it gets really to a kind of fierce cross-examination. So it should be more like open questions, not like putting too much pressure on a witness. And always these kind of procedures are only possible if the witness agrees to it. If the witness is not willing to appear before a commissioner, you need to do it before the court. So of course, if he feels to be treated unfairly, he could also say, stop, I do not want to do that anymore, and then you would have to go to the court.
Yeah, thanks, Philip, for pointing that out. The entire part 2 of the convention, I guess I scrolled through that too quickly, is voluntary. Yeah. So it's really a substitute for voluntary evidence, participation in depositions and the like.
And Peter, unfortunately, it seems that our system is not really working properly. We could only see your first slide. So if you could share your presentation, that would be great.
Sure, I can do that. Mm-hmm.
Okay, Peter, thank you again. That was a very interesting presentation. So
Brian, sorry, I had a question for
Okay, yeah,
for
please.
Peter. Yeah, Peter, I think you mentioned that you were not allowed to record this video evidence, right? What's the reasoning behind that? Because, I mean, the demeanor of the witness, their body language would be of some relevance probably to someone who's looking at the evidence at a later stage.
Yeah. Quite frankly, I cannot tell you, other than that the German judiciary and the German legal system to some extent, that they reject recordings full stop. And under our domestic system, you can record the taking of evidence, you can record a hearing, but you have to destroy the record once a protocol or a transcript has been produced. Amongst the many things that are debated right now, as part of a really fundamental overhaul of our civil procedure system is precisely that. But I can't give you a rationale. I personally don't have any good reasons for it, other than that's the way it's always been. And we haven't yet shed that tradition. And especially your standard request for depositions comes with a videographer. And of course, they want to be able to play back to the jury back in the US courtroom. They want to play back and see how you're sweating. But we can't do that as of today.
Thank you.
If there are no further questions, I think we should move to back to Carolina's presentation regarding enforcement actions in Brazil.
Okay. Hannah, is it working now to share the screen? Maybe we should try again.
Do you want to go ahead and try quickly? And if not, I have it open and ready to share.
Sure. Okay. Can you see it well like this?
Yeah, I think.
Yeah, I think we'll.
Can you please try to go to slide 2, because the problem before was that we could only see slide 1.
Yes. Can you see it now?
Yeah.
We cannot. Yes. There we go. Now we can.
Yes.
Oh, okay. That's good. That's good. So I will shortly introduce myself. I'm new here in this group. So I'm Carolina Dotto. I'm a partner in our litigation practice here at Tozzini Freire. Actually, I'm a very recent partner, just became partner in the beginning of this year. And I am very active in disputes that involve public entities here in Brazil. So we work very closely together with our antitrust, with the compliance and administrative teams. And I am also a co-head of our German desk. So it's a huge pleasure for me to be able to meet you all and to discuss on this relevant topic. And I thank Philip, Ryan, and Wendy for this opportunity. And I will start with some general remarks on the matter. So first, every foreign decision must be confirmed here in Brazil before it becomes effective here in Brazilian territory. And this is applicable to either judicial foreign decisions and also to decisions that have been issued by arbitral tribunals seated abroad. The competence for confirmation of our decisions used to belong to the Brazilian Federal Supreme Court, but the federal constitution has been changed in this regard a couple of years ago, and now the competence belongs to the president of the Superior Court of Justice, which I will refer to as the STJ. If the opposing party presents any type of objection, then the case will be assigned to a reporting justice, which will then grant the opportunities to the parties to present a reply and a rejoinder. And then the case will be judged by the special chamber of the STJ, which is composed by the elderly members of the Superior Court here in Brazil. Well, the proceeding can take a few months. In some cases, it can take more than 1 year, actually. But the reporting justice is entitled to grant provisional measures in order to ensure and safeguard the foreign decisions. So it can, for example, determine the freezing of assets or temporary restraining orders so that the foreign decision is ensured. The formal requirements are actually very simple for this proceeding. So the requesting party must present an initial complaint. This complaint must fulfill with the requirements provided under the Brazilian Civil Procedure Code. The foreign decision must be presented either in its original version or an authenticated version thereof. The party must also present a sworn translation, and documents must be duly notarized or legalized or apostilled, depending on the country of origin. And once this decision is confirmed by the STJ, it becomes an enforceable title, meaning that it will then be brought to a federal lower court. And then a second enforcement phase begins. So this lower court judge will then summon defendant to pay the due amounts. And if the amounts are not voluntarily paid, then the court will determine the attachment of assets and further sale of those attached and frozen assets. In this confirmation proceeding, we say that the litigation is very limited because the arguments that can be raised by defendants are very, very narrow. So in relation, the requirements for both judicial and arbitral awards are actually very similar, as you can see from these both tables here. And they will only not be confirmed by the STJ if they, for example, have not been rendered by a competent court, if there has not been a regular summoning, if it violates a decision that has already become final and unappealable here in Brazil, or if it represents an offense to the public order. A couple of years ago, it was a requirement that the foreign decision should be final and unappealable, but this is no longer a requirement under Brazilian law, so it is sufficient that the foreign decision is enforceable, that is, it can already be enforced abroad. So if it is already enforceable, it can be brought for confirmation to the STJ, even if it is not yet final and unappealable. In relation to arbitral awards, the Brazilian Arbitration Act pretty much mirrors the requirements provided under the New York Convention. I will not go into each one of these requirements because I think you have already discussed them in depth in previous meetings. And I will bring some cases in the next slides in which those requirements have been discussed. But I think it's worth mentioning that the STJ has a tendency of respecting and endorsing foreign decision and especially in also arbitral decisions rendered abroad. So in most cases, the decisions are confirmed if these formal requirements are duly observed. When parties bring arguments related to public order, they are only exceptionally admitted because otherwise it is understood that the party that is arguing public order violation is trying to relitigate the matter, which is not admitted in this narrow proceeding for confirmation. So now I will bring some concrete cases. Of course, there are many, many cases. I could talk to you here for hours and hours. So I have tried to bring some relevant and recent discussions. They're not in a chronological order. They are random here in my PPT. But I will start with one case, which is very interesting. And actually, our firm represented one of the parties in this case. And we're very proud of the result thereof. In this case, the foreign arbitral decision was denied by the STJ. The case had initially been judged, been resolved by the ICC in New York. And the parties were discussing the fact that the defendant had allegedly omitted relevant information during due diligence. related to an acquisition transaction, and the defendant would also allegedly have violated reps and warranties provided under the SPA. And those reps and warranties were mainly related to the capability of processing of sugarcane in the sugar plants. So the ICC condemned defendants to pay more than 100 million US dollars plus monetary adjustment and interest. And the case was then brought to the STJ for confirmation. The defendant argued the lack of neutrality of the chairman of the arbitral tribunal. And this is so because the chairman belonged to a renowned law firm. And this law firm had actually represented one of the parties in different transactions and had received lots of money because of these previous transactions. So defendant argued that there would not the chairman would not be neutral in this case and would not be impartial. This argument had already been raised before American federal courts, and the American federal courts rejected this argument of lack of neutrality because it held that there was actually no proof of this violation by the chairman of the tribunal. So when analyzing the case, the reporting justice of the STJ initially held that everything was okay. He held that all formal requirements had been duly fulfilled. So the party had presented a sworn translation of the decision. All documents were duly notarized. Everything was okay. And he also quoted several precedents of the STJ, which mentioned that the merits of the foreign decision cannot be reassessed by the STJ. The case was then docketed for judgment, and then another justice requested access to the case records, and he actually adopted a different view on the matter. So this different justice recognized that only in very exceptional circumstances can arguments related to violation of public order be recognized. They can only be recognized when there is an absolute incompatibility of the decision with the Brazilian legal system. However, he also understood that the violation of the duty to disclose by the arbitrator represents a violation to the Brazilian due process of law, and therefore he held that there was a violation to the Brazilian public order. And I will quote here a relevant part of his decision. He stated that, given the contractual nature of arbitration, which presupposes the trust relationship between the parties and the arbitrator, the breach of an arbitrator's duty to disclose any circumstance that are reasonably capable of casting a doubt over his impartiality prevents the confirmation of the arbitral award in this country. So in this case, this very relevant arbitral decision rendered in New York could not be confirmed by the STJ. It was rendered in the year of 2017. I will now briefly mention another case which has been very recently judged by the STJ. So in this case, it was held that the foreign decision could not be confirmed by the STJ because it was held that there was no direct utility and no direct benefit to the requesting party because it could actually not be enforced in Brazil. So in the grounds of the foreign decision, that was a part stating that defendants had somehow forged documents, but there was no condemnation to pay any amounts to the claimants. So the STJ held that this could also not be enforced here in Brazil. In relation to the condemnatory part of this foreign decision, the foreign decision did not clearly establish what obligations were due and also did not establish the exact amount of this obligation, and therefore it could also not be enforced here in Brazil, reason why this proceeding was also not confirmed by the STJ. We have also made some recent researches on statute of limitation. So we had initially thought that because statute of limitations is a matter of public order here in Brazil, maybe the STJ could reject confirmation on those bases, but actually it's quite the opposite. The STJ holds that this belongs to the merits of the discussion. So if the foreign decision has already analyzed and held that the claim is not statute bar, the STJ cannot reject confirmation in these types of cases. Also, another relevant case. So this was a conflict that was resolved by a German arbitrator. The STJ reanalyzed the agreements between the parties and held that the foreman agreement had been substituted by a termination agreement, which on its turn provided that any conflict should be resolved by 3 arbitrators. Considering that the decision had been rendered by a single arbitrator, the STJ also did not accept confirmation of this foreign decision. And one last point that I wish to discuss with you. So we are now part of a very interesting discussion, and the case has been judged by an European court. And in that case, actually, Brazilian law has applied because the parties had agreed on the applicability of the Brazilian law. In this case, an unfavorable decision has been issued against the client. So the client was asking us, okay, despite of this decision rendered abroad, can I also file a proceeding here in Brazil to discuss the same facts? And actually, the answer is yes. It is possible to file a proceeding here in Brazil despite the proceeding abroad because there is no lis pendens in relation to discussions that are being held abroad, even if a decision has already been rendered abroad. And then we were discussing, okay, in this case, if this foreign decision is brought to Brazil for confirmation, which one will prevail? And the answer is that the one that first becomes final and unappealable is the one that will prevail. So if the confirmation proceeding of the foreign decision becomes final, it will prevail over a decision rendered by a Brazilian court. So I think this was it. Thank you very much, and I will be glad to discuss if you have any question, and I will also be very interested in hearing how this is handled abroad. Thank you very much.
Thank you, Carolina. That was extremely interesting. So does anybody have any questions for Carolina? Okay, so Carolina, again, thank you. That was a very interesting discussion. I do have one question. So on this lis pendens issue, as I understand the law in Brazil, is that you are permitted, or you can. There is no lis pendens recognition in the sense that you can file a proceeding in Brazil before the foreign proceeding becomes final. Is that right?
Yeah, actually, before the foreign proceeding is confirmed, and this confirmation becomes final and unappealable.
And so once that happens, that foreign, let's say, award, it becomes recognized. Does that essentially eliminate the Brazilian proceeding that would seek to challenge or perhaps seek a different result?
Yes, if the decision is confirmed by the STJ, then it will no longer be possible to file a new proceeding here in Brazil.
Okay.
But only after it is confirmed.
Okay. So the finality issue, I guess, is the key distinction, right?
Yes, exactly. And as long as Brazilian courts have also jurisdiction to rule on the matter, of course. Very
good. Okay, thank you very much. And by the way, congratulations on your partnership. That's very exciting.
Thank you very much, Ryan. Thank you.
So if there are no further questions for Carolina, I thought I would check to see if Yoko has been able to join. I know she, again, had a conflict and was going to try to present the dispute resolution team at City-Yuwa Partners. But hearing no response, I'm assuming that Yoko has been unable to join us and get and complete her.
Ryan, I can see her. She has
I'm
just
here.
unmuted.
Okay, I'm sorry.
Hi, Ryan.
I couldn't
everyone.
see. Welcome, Yoko.
Thank you very much. And I'm sorry, I'm terribly late, but I'm happy to be here, and I'd like to introduce. By the way, is it okay that I introduce generally about City-Yuwa's practice and also about kind of area of industry that frequently end up in dispute in Japan, right? Not about enforcement specifically, like Karina did. Is it? I hope it's okay.
Yeah, that would be fantastic.
Okay, very good. So again, thank you very much, everyone, for giving me this opportunity to present about the practice. And City-Yuwa Partners is the seventh largest full service law firm in Japan. But unlike other full service law firms in Japan, City-Yuwa has a very large dispute resolution practice team, and about 1/3 or maybe more lawyers do some kind of litigation. And each partner has his or her own strengths or unique area of practice, like IP dispute or real estate dispute, banking finance, class action, or other commercial or corporate dispute. But my own practice is I'm focusing on international arbitration and cross-border litigation. So that's why I try to introduce in which area of industry Japanese, like international dispute in Japan frequently occur. And one of the most frequent area of industry is, as you can imagine, is a construction in Japan. And what is unique in Japan is that the construction dispute frequently occurs in a solar power plant construction. And that is partially because of Japanese law, which is called FIT Act. That means like Feed-in Tariff Act, which was introduced in 2012. And under this act, the Japanese government guaranteed to purchase power generated by renewable energy plant at fixed price and at for fixed term. And because of that act, many construction companies, including many foreign construction companies, started to construct and develop new renewable energy power generation plant. And such project has generated not only the electricity, but also substantial number of international dispute, especially international arbitration cases. And so the cause of such dispute is like there are various causes such as delay or poor quality of the construction or non-payment of the construction prices as usual in construction dispute. And another kind of interesting and also unique area of construction dispute that our team is representing is in relation to Tokyo Olympic Game and COVID-19, which is very kind of a hot area. And as you may be aware, because of COVID-19, the international freight cost increased significantly, actually. And my client is, again, it's construction company, and it contracted certain area of construction project for Tokyo Olympic Game, and my client imported certain equipment for such construction in Japan. But because of COVID-19, as you know, the Olympic Game itself was postponed for 1 year. And so that equipment, very huge equipment, needs to stay in Japan for another year, 1 year longer than initially scheduled. So when the game has ended and the client tried to send the equipment back to the original place, the freight cost was about 5 times higher than initially estimated before COVID-19. So the client is now claiming for such increase in the freight cost above other things. And separately from or in addition to the construction dispute, another area of dispute, another area of frequent international dispute in Japan is pharmaceutical and medical equipment dispute, from my experience. And I'm not sure whether this is also true in other jurisdictions, and maybe would be the case, but I don't know why exactly there are so many disputes in this area, but my guess is because in this industry, so the investment amount is huge and the contract amount also tends to be huge. And I also understand that the regulation, there are many regulations related to pharmaceutical and medical equipments, but those local mediation is different from one jurisdiction to one jurisdiction. But sometimes multinational pharmaceutical companies do not pay sufficient attention to those, the differences in local regulation and just do what they want to do, and that ends up in dispute. So as an example, the one case that I recently handled it's a US medical equipment company, was my client, and it entered into a distribution agreement with Japanese subsidiary. And they started to sell, they started to distribute medical equipment. But after the launch of the equipment, the government agency called PMDA, which is similar to FDA in the US, intervened and stopped the use of certain language in the package of that medical equipment, saying this is not allowed in Japan. But because that language was the most important and attractive feature of that equipment, it ended up in the arbitration between the manufacturer and the Japanese distributor, and the dispute was mostly about whose fault it is. And lastly, I'm aware that we already have running out of time, but just wanted to introduce that it is not about specific industry, but in Japan, something called continuous contract theory often becomes cause of dispute. And this is a legal theory which is established by court cases in Japan. And under this theory, if a contract has been in effect for a long time, or if the contract has been renewed for multiple times, the party is not allowed to terminate the contract without kind of absolute necessity, even if the contract itself has a fixed contract term. So I often see dispute in this, in relation to this theory in continuous contracts, such as distributorship contract or license agreement or things like that. So that's it from me, and I'm happy to answer any questions if you have.
If there are any questions, please let us know. I know we're a couple of minutes over. That was very interesting. I think it's always beneficial to the group to hear, what our dispute resolution colleagues do in our various firms, and to learn more about the dispute resolution practices within the firms of the World Law Group. So thank you very much for that brief overview of City-Yuwa, and I think we look forward to the next meeting. Hopefully some people can make it to our next conference, and we'll get to know each other even better. If there are no questions, I think that's it. Hannah, I don't believe we're going to have time for our speed networking. Hopefully
that is correct.
Hopefully at one of our next calls, we'll be able to do that. But again, on behalf of Philip and Wendy, I know Wendy was not able to join due to a conflict, but we thank everybody very much for participating, and look forward to seeing you all soon.
Yes, and we also please volunteer if you're interested to do presentation like we had today from Brazil about about the enforcement of foreign awards in your country. I think probably next time it could be a country from Asia, and we have quite a number of participants from Asia today. So if you would like to present the next time, please let us know, or please let Hannah know, and she will inform us. Or if you have another interesting topic like Peter today, we are really happy to hear about that and to give you an opportunity to present. And thanks.